Hello there, and welcome to One Chancery Lane's second weekly webinar. This webinar is on how to argue the meaning of a contract. This is actually the second time today that I'm presenting this webinar. The first time I forgot to record, so this is a webinar without any participants and is going on our website. But the second part of the webinar was recorded. My colleague Justin Althaus will be dealing in that part with an example of how the principles that I'm going to be talking about were put into practice by the Supreme Court in the case of Duval. The questions which were asked by our participants, I'm going to work into my presentation on how to argue the meaning of a contract. I should say that what I'm about to do derives from some training that one of our pupils asked about and caused me to think about what it is lawyers do when they're arguing about what a contract means. And I'm not suggesting that there's anything in what I'm saying that's necessarily going to be particularly new or devastatingly original, but I have found it helpful myself to deconstruct the way it is that I work when I'm trying to argue or analyze what it is that a contract means. And the first thing that I realized myself is that the starting point is what are the rules of interpretation that the courts apply when they're interpreting what a contract means. And that's the basis on which the lawyer begins to create his argument. And what I think I found are there's potentially 4 different ways in which you can win the argument about what the contract means for your clients. So I'm going to share my screen with you for some PowerPoint slides, setting out what it is that we think So these are our learning objectives for this webinar. And as I said, an important part of it is actually looking at the basic principles that the courts apply when interpreting a contract and identifying within those principles some tensions which you can use to argue one way or the other as to what it is that a contract means. So this is a potential reading list for you, mostly Supreme Court cases, or you can jump to the Tucker and Brittany case in paragraphs 26 and 27 of his Honour Judge Pelling's judgment, which sets out a lot of the principles which I'm going to be talking about. So the interpretation of a contract, what is it that we're doing? What is it that the court is doing? And we, of course, have this classic description by Lord Hoffman in the Investors' Compensation Scheme case, where he said interpretation is the ascertainment of the meaning which the document would convey to a reasonable person, having all the background knowledge which would reasonably have been available to the parties in the situation which they were at the time of the contract. So we get from this that it's an objective test, but it's a test that also incorporates and requires one to look at background circumstances that the parties were in when the contract was entered into. So what can we look at? We can look at, of course, the words of the contract, we can look at commercial common sense, and we can look at the factual matrix. And I'm going to talk about what commercial common sense and what the factual matrix involves in more detail in due course. And there are some things we can't look at. We don't look at the subjective intentions of the parties. We don't look at pre-contractual negotiation material, that's inadmissible. That's Chartbrook and Persimmon. And we also don't look at post-contract conduct and events of the parties. There's an exception to that rule in relation to boundaries, and Allen Lane is the Court of Appeal authority for that proposition. So the first thing we look at, and the most important thing to remember, is the primacy of the words the parties have actually used. So in Arnold and Britton, Lord Neuberger said this: the exercise of interpreting a provision involves identifying what the parties meant through the eyes of a reasonable reader, and, say perhaps in a very unusual case, that meaning is most obviously to be gleaned from the language of the provision. And so for all the discussion about commercial business sense or factual matrix, at the end of the day, in the majority of cases, you get your answers to the meaning of the contract by looking at the words in the contract or analysing the words the party spoke if it was an oral agreement. And that point is reinforced by what Lord Clark said in the Rainy Sky case, where the parties have used unambiguous language, the court must apply it. Lord Clark gave an interesting example of the Cooperative Wholesale Society case, which is a series of rent review provisions which were said to lack common business sense. But where the language was used was unambiguous, the commercial sense, the assumption of reality in the rent review clause had to give way to the unambiguous language in the clause. So if you've got unambiguous language, that's the first way in which you can win the case. And the court respects the language used by the parties, firstly because the parties have control over the language they've used when they've drawn up a contract. And also Lord Neuberger said in Arnold and Britton, because the parties must have been specifically focusing on the issue covered by the disputed clause or clauses when agreeing the wording of that provision. So way to win number one is our unambiguous language. And I have a picture of David Seaman wearing an unambiguously hideous jersey to represent that first number one way to win. So if you don't have unambiguous language, then what? So in Arnold and Britton, Lord Neuberger said this: when it comes to considering the centrally relevant words to be interpreted, accept that the less clear they are, or to put it another way, the worse their drafting, the more ready the court can properly be to depart from their natural meaning. That is simply the obverse of the sensible proposition that the clearer the natural meaning, the more difficult it is to justify departing from it. So Lord Neuberger there is imagining a spectrum of drafting from the well-drafted contract in one case, where it will be difficult to depart from the natural meaning, to a more poorly drafted contract, where the court will be more ready to depart from the natural meaning. Now, what Lord Neuberger said in Arnold and Britton can be contrasted with what Lord Clark had said in Rainy Sky. Lord Clark in Rainy Sky said this: where a term of a contract is open to more than one interpretation, it is generally appropriate to adopt the interpretation which is most consistent with business common sense. So there Lord Clark is putting the emphasis not on the standard of drafting of the contract, but on which possible interpretation complies with business common sense. And there's a clear tension with the idea that Lord Neuberger was suggesting in Arnold and Britton about the clearness of the words which one party is seeking to persuade the court to depart from. So how can that tension be resolved? Well, in Wood and Capita, Lord Hodge, with whom both Lord Neuberger and Lord Clark agreed, had the task of trying to reconcile what was said in Arnold and Britton and what was said in Rainy Sky. And he didn't have any difficulty in doing so, because what he said is that what the court must consider the contract as a whole, and depending on the nature, formality and quality of the drafting of the contract, give more or less weight to elements of the wider context in reaching its view as to that objective meaning. So the point that Lord Hodge was making is that when one is looking to consider the weight to be given to business common sense with actual matrix, one can look at the quality and the nature of the drafting itself. But even that's subject to provisos, which Lord Hodge reminds us of, the difficulties that one has with even the most complicated and sophisticated document. Negotiators of complex formal contracts may often not achieve a logical and coherent text because of, for example, the conflicting aims of the parties, failures of communication, differing drafting practices, or deadlines which require the parties to compromise in order to reach agreement. There may often therefore be provisions in a detailed professionally drawn contract which lack clarity. So even where we have a well-drawn contract, that's no certainty that the parties can't argue that departure from the language is required to give business common sense to the contract. It's important to remember that in this context, what the court is doing, what one is doing when interpreting the contract, is a unitary exercise. Lord Hodge described it this way: this unitary exercise involves an iterative process by which each suggested interpretation is checked against the provisions of the contract and its commercial consequences are investigated. So the process of interpreting involves looking at all the possible interpretations, comparing them those interpretations of the wording of the contract, how well does it fit in with the contract, and also the commercial consequences of an interpretation and the factual background as well. So way to win number 2 is a harder way to win the case, and that's why I've got the Mitchell brothers as my example for number 2. And the way to win number 2 is testing possible meanings against business common sense and the factual matrix. Now I'm going to say a little bit more about what business common sense and the factual matrix are. So first of all, business common sense, it is not to be judged retrospectively. So very often you may get a situation where the contract works out very badly for one particular party, and it's said that the interpretation of the party who's benefited from the events which have happened defies business common sense. But you're not to judge business common sense retrospectively, you're to judge it at the time that the parties entered into the contract. The other point to bear in mind is that one party may simply have entered into an imprudent contract. It may simply have been a bad deal, and the court's not there to determine what a reasonable deal would have been or to rewrite the contract for the parties. Other points about the limit to which business common sense can be applied, suggested in Wood and Capita. A provision which appears to lack business common sense may be part of a negotiated compromise. It may be a quid pro quo. So just because an area of the contract appears to lack business common sense doesn't mean to say the court should depart from it. And again, it may be that the negotiator simply couldn't reach precise terms on the particular issue between the parties, and something has been left vague, potentially lacking in business common sense for that reason. One of the questions that was asked during the webinar was what happens if the party who is alleging there's a lack of business common sense is actually the party who drafted the terms? How does that play out? Well, it seems to me that where the party who is alleging that the contract lacks business common sense is running that argument, that they have a difficulty of the fact that the term originated from themselves. But that's not to say that they are going to be stuck with the particular interpretation, because then mistakes can be made, there's lack of clarity in language, and many of the standard terms and conditions that I've seen, one could draw out a meaning from some part of the document which would lack business common sense. It might not be the most obvious meaning, but might lack business common sense. And the courts aren't going to enforce a interpretation which lacks business common sense when the purpose of the document, the purpose of the contract is known. It does seem to me that a party who has produced the draft is going to struggle to persuade the court to depart from the language more than where a party's has not produced the document. And I think that's part of the points made in Wood and Capita about the drafting and where it comes from, and the reconciliation of Rainy Sky and Arnold and Britain. So the factual matrix is the next thing to mention. What Lord Hoffman said in Investors' Compensation Scheme was subject to the requirement that it should have been reasonably available to the parties. It includes absolutely anything which would have affected the way in which the language of the document would have been understood by a reasonable man. So that's potentially a very broad category of matter that can be looked at. And one of the difficulties that gives rise to is the extent of the material, the extent of the disclosure, the expense of the litigation, which can arise from what might otherwise be a simple investigation as to what something means. And there's a limit on what one can look at. Lord Newberger makes the point in Arnold and Britain that given that a contract is a bilateral or synallagmatic arrangement involving both parties, it cannot be right, when interpreting a contractual provision, to take into account a fact or circumstance known only to one of the parties. So both of the parties have to know or have the material readily available to them for you to take that into account. I once argued in a case called Ali and Bashir that it was possible for neither party to be aware of the circumstance, and you could take that into account because contracts to be construed objectively, but that was rejected. Lord Newberger makes it very clear in Arnold and Britain that both parties have to be aware of the material. Quick point about pleading. It seems to me that good practice would be that you plead out the elements of the factual matrix on which you're relying for your construction of a particular contract. I give a reference to the relevant bits in CPR 16.4 for the particulars of claim, point 5 of defence, which you can point to for that view, and the commercial court guide passage, which does require a party to specifically plead out the factual matrix elements which it's going to rely on. Now, a further point then comes to drafting errors. So this second way of winning, where you're looking at different meanings of the contract and trying to encourage the court that one particular construction is to be preferred because of business common sense or the clarity of the language, depends on, to depart from the clarity of language, depends on more than one possible meaning. One point made in Arnold and Britain is that the court's not in the business of looking out for drafting infelicities in order to facilitate a departure from the natural meaning. Furthermore, an error in the drafting may not actually be of relevance to the dispute that the court has to resolve. Now, this is in some ways the converse of what we sometimes call the correction of mistakes by construction, which is something that Lord Hoffman drew attention to in Chartbrook and Persimmon Homes. And this is the idea that sometimes parties make linguistic mistakes, language is misused, and even in a conversation we will recognise when language is misused. When, for example, somebody calls me by my son's name rather than by my name, I know exactly what it is they mean. In the same way, one construes contracts in that way. But there are two conditions. Firstly, there must be a clear mistake on the face of the instrument. Secondly, it must be clear what correction ought to be made in order to cure the mistake. And so there you that's often that second hurdle is often where one falls down with this type of argument about correction of mistakes by construction, because there may be more than one alternative way of dealing with what the mistake would have been. And if there's more than one alternative, then you can't rely on this way of arguing the case. Further point made by Lord Hoffman in Chartbrook is that when deciding whether there is a clear mistake, the court is not confined to reading the document without regard to its background or context. So you can look to what the party's background, factual matrix information was, the commercial purpose of the document, in order to show that there's a clear mistake on the face of the instrument. So this is my third way of winning a case, the clear mistake with a clear answer. And my illustration for that, for my number 3 point, are the three stooges who made many, many clear mistakes in the course of their movies. As I told my colleague Justin when we did this morning, there's a very charming video on YouTube of the three stooges genuinely injuring themselves by making clear mistakes in the course of their buffoonery. Further way of arguing the meaning of the contract is to rely on some implied term. Now, strictly an implied term is not construction of the word meaning of the words, but it is nevertheless part of the process of determining the scope and meaning of the contract. And what is said in Marks and Spencer's and BNP Paribas is that different rules apply, and that you need to construe the contract as a whole, because not until you've construed the contract as a whole, you can't decide whether an implied term is required. And a term will be implied into a detailed commercial contract only if it were necessary to give the contract business efficacy, or so obvious that it went without saying. And I'm not going to say anything more about implied terms, because the case that Justin's going to talk about concerns an implied term, and is a very good illustration of the circumstances in which an implied term will be drawn into the contract, and the process by which the court analyses what a contract means without the implied term before it decides to imply a term. So that's my way to win number 4, the term to be implied as necessary for business efficacy or obviousness. And my illustration of this to help you remember it is the Arsenal back four offside trap. Very business efficient, and we have a Norwich player who is obviously offside. So that's my way to win number 4. Now, one of the questions that we were asked was in relation to the coronavirus pandemic and the question of force majeure and or frustration. And this isn't really the place to talk about that, but the point to make, though, is that in order to determine whether the contract has been frustrated, the court has to go through a very similar process as it does when implying a term, because the court has to ask itself, have the circumstances which have arisen required a performance of a contract which is so radically different from what the parties have agreed that it wouldn't be fair to hold the party who has to perform to the terms of the contract. And in order to reach that decision, the court has to construe the contract, identify the parties' expectations, and that of course involves looking at the background to the contract, looking at the commercial purpose of the contract, looking at the meaning of the words that the parties have used, identifying where risk lies depending on the words used. So it's going to depend in each case where you're looking at frustration, whether or not the expectations of the parties are defeated by the events that have arisen. And that's a process of essentially of construing the contract before you come to ask the question of whether or not circumstances have arisen to frustrate that particular contract. Another question we have asked, which is perhaps relevant to this point, the clear mistake with a clear answer, was the question of, you sometimes see choice of law clauses where the choice of law is UK law. Now, UK law doesn't really exist. We have 3 legal systems in the United Kingdom. One we're most familiar with is the legal system of England and Wales. What do you do with a choice of law provision which relates to UK law? Well, it seems to me that by reference to what Lord Hoffman is saying in Chartbrook, you can have regard to the background and context of the document. And if you are dealing with a contract which has its locus in England and Wales, perhaps a contract is to be performed in England and Wales, or one of the parties is based in England and Wales, or the intention is that litigation will be in London, one might readily infer that the legal system of the United Kingdom means, or the legal system of England and Wales. There's a clear mistake on the face of the instrument. It's referred to a legal system that doesn't really exist. A correction is England and Wales. But a different context may support a different inference. So other ways of arguing about the mini contract mustn't be forgotten. Don't forget you've got rectification, arguments about estoppel and sham as well, where you can rely on subsequent conduct. Rectification is an interesting one because it allows you to bring in evidence of the pre-contractual negotiations which would otherwise be inadmissible when arguing about the meaning of the contract. And before the webinar, we had a question about whether it would always be appropriate to argue rectification. And it seems to me that really the question is, what would be the circumstances where you would not want to run rectification as well, assuming that you had a reasonable argument of rectification. And it seems to me that there might be 2 reasons why you might choose not to. One would be the additional expense you would incur, your client would incur, of running rectification, because you would be opening out a broader area of factual dispute. And you might prefer not to do that for various reasons. The other possibility is that there may be things within the material which will become admissible because you argue rectification, matters that you didn't want the court to see for some reason. Your client might not have behaved itself as well as it ought to have done, and you might be concerned that this would discourage the court from coming to the construction that you wanted to advance. So those are 2 reasons why you might not run a rectification case, where there was within the material that you had matters to support your argument that rectification was an alternative to your construction argument or your correction of an error argument. So having looked at then the ways in which we can win the argument, it's worth reflecting the skills and knowledge which, as lawyers, we require to argue these cases for our clients. And the first is really a linguistic ability to identify the meaning of the contract or the obvious meaning of contract, but more importantly, to identify ambiguity and possible alternative meanings. Secondly, we need commercial awareness. And I hope what I've shown in looking at the principles which the courts look at, that commercial awareness is quite a broad sense. We need a commercial awareness of the industry in which our clients are operating. We need awareness of the transaction. We need an awareness of the negotiation itself and how that represents the norm in the industry or does not represent the norm in the industry, in terms of, are we going to be able to persuade the court to depart from what might otherwise be clear words and look more to business common sense. Some awareness of how the negotiation has progressed is going to assist us. And then, of course, we need to have a appreciation of what the commercial purpose of a particular clause, the disputed words that we're looking at, what other parties are likely to be achieving through this particular bond or this particular overage provision. And then finally, we need to be able to recognise what might be relevant factual circumstances that support our construction. One of the difficulties with the breadth of the definition of factual matrix, it can be potentially very broad, but really to advance a case with clarity, one wants to be able to home in on those matters of the factual matrix which really do go to the root of the construction which one is arguing. So this slide sets up some helpful questions that I find it to test arguments of construction with when thinking about arguing the meaning of a contract. So one question is always, what would the draftsman have said if a contract really meant X? So one might see the contract having particular language in a particular place where the draftsman is expressing a particular concept. If that language is absent elsewhere, it might suggest the draftsman has a different meaning in mind. And there's other illustrations of that type of situation one can think of. Next one, do all provisions in the contract have a purpose if the contract means X? Very often one gets the situation where if a particular provision has a particular meaning, then another provision no longer has any purpose in the contract. Now, that may or may not be a decisive point, but it's certainly an important point to be aware of. Then the third point is really testing out what are the consequences if the contract has a particular meaning. Could it lead to absurd results in scenarios which are reasonably realistic? If it does, that might suggest that the construction that you're looking at is incorrect. Then another question to ask yourself is it really in the client's interest to argue that the contract means X? And that really particularly comes into play where you have a dispute where there is going to be more than one argument about the meaning of the contract. So different disputes about different parts of the contract. Arguing construction one on a particular part of the contract may involve an aspect of the second argument in the case being slanted in a certain way. So if argument one depends on, let's say, clause 5 not having a particular effect, it may be that when you come onto the second argument, if clause 5 doesn't have that effect, you lose on point 2. So you do need to have a holistic view of how the contract works and how the dispute is going to progress. And you need to bear in mind as a lawyer that the dispute that you're being asked about initially may not ultimately be the key dispute, the key issue in the contract. So you need to have a broad view as to where this dispute ultimately is going to go. So finally, there's a suggested structure of how you might set out an argument. There's nothing particularly special about this, nothing particularly original. Other methods are possible, but this is a method I've seen opponents use and I've used myself as to how to set out the basis of the argument. And whether you're doing this by correspondence or in a skeleton argument, this sort of structure can work. So first you want to identify what the issue is and what your version is, so everybody knows where you're going. You want to set out the factual background, issues, if any, put out the relevant contractual terms. Now, my preference is to do this relatively fully because the meaning of the disputed words is going to depend on the provisions which it operates within and around it. And I also quite like to set out in full the key area of dispute, and I quite like to type that out rather than cut and paste it, because personally I find the process of actually typing something out often gives one insight into the language which one doesn't necessarily get just from reading it the first time. That's just a personal thing that I find. You might then set out any relevant post-contractual events. There may not be any that are relevant. And then you want to set out the reasons supporting your version, including you want to set out the relevant legal principles if you need to, and that may be very brief. They are often not in dispute. But as we've seen earlier, there are some tensions in the way that they can be presented. Your contextual analysis of language, the commercial reasons why you are right, and any parts of the factual matrix in addition to commercial business sense that support your case. So that's just a possible structure. There, as I said, there are other ways of doing it. That's something that I feel it has a certain logic to it, and you may find helpful. Thank you very much for listening to my talk, and Justin is going to deal with the issue of Deval, and I hope, and yes, and well, thank you very much for clicking on our link and listening to our webinar.
Randolph Crescent, Maida Vale in London. That company is owned by all the tenants in the flats. Dr. Julia Duval, the respondent, is the tenant of 2 of the 9 flats, and Mrs. Martha Winfield is the tenant of one of them, the basement flat at number 13. Each of those 9 leases they're all 125-year leases, they're long leases, they're in substantially the same form, and they contain the following relevant covenants. I'm afraid you'll just have to look at them. You need to set them out. I've typed them out as Zach suggested we should do, and it's useful for me to have done that too. Here's the first one, clause 2.6. This is a tenant's covenant, not without the previous written consent of the landlord to erect any structure, pipe, partition, wire, or post upon the demised premises, nor make or suffer to be made any alteration or improvement in or addition to the demised premises. That is a qualified covenant in that those works can be done with the previous written consent of the landlord, and by virtue of section 19 subsection 2 of the Landlord and Tenant Act 1927, it is deemed that the consent there of the landlord is not to be unreasonably withheld. So that's clause 2.6. The second one is clause 2.7, which is headed waste, and that says that the tenant covenants not to commit or permit or suffer any waste, spoil or destruction in or upon the demised premises, nor cut, maim or injure or suffer to be cut, maimed or injured any roof, wall or ceiling within or enclosing the demised premises, or any sewers, drains, pipes, radiators, ventilators, wires and cables therein, and not to obstruct but leave accessible at all times all casings or covering of conduits serving the demised premises and other parts of the building. That is an absolute covenant, because unlike clause 2.6 there, where there's a provision which entitles the tenant to ask consent, there is no such provision. That is an absolute obligation on the tenant not to do any of those things. And then there's the landlord's covenant here, and this is really the most important of all. This is clause 3.19. This is a covenant it's an obligation on the landlord. And it says that every lease of a residential unit in the building, that's to say 11 to 13 Randolph Crescent, hereafter granted by the landlord at a premium, shall contain regulations to be observed by the tenants in similar terms to those contained in the 5th schedule hereto, and also covenants of a similar nature to those contained in clause 2 and 3 of this lease. Clause 2, you'll remember, includes the 2 we've just looked at. and at the request of the tenant and subject to payment by the tenant of and provision beforehand of security for the costs of the landlord on a complete indemnity basis, to enforce any covenants entered into with the landlord by a tenant of any residential unit in the building of a similar nature to those contained in clause 2 of this lease. So what does that mean? In summary, each tenant is covenanting not to carry out alterations or improvements without the previous written consent of the landlord. That's clause 2.6. Not to commit acts of waste, spoil or destruction. That's clause 2.7. And the landlord covenants with each tenant that it will enforce the equivalent of those covenants in any of the other leases at the behest of that tenant, on condition that the tenant gives security for payment of the landlord's costs and duly pays those costs. Here, by the way, because it's very important, here's a picture of 11 to 13 Randolph Crescent. Just to show that I didn't take that off Google Maps, but went there on Sunday during my government-approved exercise bicycle ride, is the doorbell for flat 411. And one of those, I think it's G, is one of the ones that Dr. Duval is the tenant of. Find a panel for number 13, so I don't know how visitors to Mrs. Winfield get in. Incidentally, Dr. Duval is she is a research scientist. Mrs. Winfield is a yoga teacher. Ominously, however, they're both married to lawyers. I know that because you can find out an awful lot on Companies House if you look at the management committees, the company details of the directors. Of course, all of these tenants are directors of the claimant. So what happens? Well, what happens is that in 2015, Mrs. Winfield asks the managing agents for a license to carry out works, including the removal of a load-bearing wall at basement level. It's common ground between the parties that those works fall within the ambit of clause 3.7. Remember, that's the absolute covenant, the prohibitory covenant. However, the landlord has a look at the engineers and the architect's designs, and having seen them, is minded to grant a license because it's satisfied that it wouldn't compromise the structural integrity of the building as a whole. And of course, if it grants a license, it will then mean that Mrs. Winfield will not be acting in breach of clause 3.7. Effectively, any such breach would have been waived by the license. Dr. Duval objects to this, and she twice asks the landlord to secure an undertaking from Mrs. Winfield not to breach the clause. Dr. Duval says that she will indemnify the landlord for its costs if legal action becomes necessary against Mrs. Winfield. However, the landlord refuses to secure an undertaking from Mrs. Winfield. So there is a standoff between Dr. Duval on the one hand and effectively the other tenants in the building who are collectively the landlord. And the proceedings then begin in May 2016. Dr. Duval issues a claim against the landlord seeking a declaration that it would be in breach of clause 3.19 of her lease if it granted permission to Mrs. Winfield to carry out the proposed works. The case reaches Deputy District Judge Chambers in January the following year, and he finds for Dr. Duval. He finds that the landlord had no power to waive clause 2.7 or to grant a license without the prior consent of all the other tenants. So round one to Dr. Duval. Round two is an appeal to His Honour Judge Parfitt in Central London County Court in July of the same year, who allows the landlord's appeal, holding that the landlord did have power to license works that would otherwise be a breach of that clause, that once the license had been granted, there would be no breach. Ergo, works could not be the subject of enforcement action under clause 3.19. Ergo, there would be no breach of clause 3.19. The proceedings rumbled on, and they reached the Court of Appeal in October 2018. Lord Justice Lewison gave the lead judgment, and the court allowed Dr. Duval's appeal. It held that whilst the landlord has power to license the works, therefore disagreeing with the Deputy District Judge, and thereby waive breach of clause 2.7 in Mrs. Winfield's lease, to do so would amount to a breach of clause 3.19 of Dr. Duval's lease. That clause 3.19 imposed a conditional obligation to enforce upon provision of security, and it was subject to the implied term that the landlord would not put it out of their power to comply with that obligation, that if and when the tenant complied with the condition by providing the necessary security. I'm sorry, there's a spare that in that particular paragraph. And eventually then it reached the Supreme Court in May 2020 when Lord Kitchin gave the only judgment, and the Supreme Court dismissed the landlord's further appeal. Do we need to, or do I need to find out from you, Zach, whether anyone wants to ask any questions at this stage? Sorry.
We don't have any questions yet, Justin, so I'll carry on.
On I go. I'll make two other observations at this point. The first is that the higher the parties progressed up the appellate ladder, the further they had to stretch to reach the next rung. It only took 6 months to get a decision out of His Honour Judge Parfitt. It took another 15 to get one from the Court of Appeal, and another 19 after that to get one from the Supreme Court. This is not untypical, of course, but given that each time you appeal there are more judges to spread the load of deciding whether the decision below was right or wrong, you might have hoped it would work the other way around, but it doesn't.
Can I ask a quick question, Justin?
Yeah, I can hear you.
Yeah, what was it about this case you think that caused the Supreme Court to give permission?
I think it was because this kind of provision is commonplace in leases of this kind, and it was because of the potential. It was potentially important whether landlords were going to be obliged to enforce these terms, or whether they could waive them by granting license, because this is an entirely standard set of covenants that one finds in long leases. So I think that must be the only reason why the Supreme Court was prepared to consider it. The other thing I was going to say was that like any Deputy District Judge worth her or his salt, Deputy District Judge Chambers in this case reached the right decision, but for the wrong reasons. And I wonder why the parties couldn't just have settled for that. And they could have saved another 3 or 4 years of litigation. So this is my attempt to shoehorn this case into what we're talking about. How does the Supreme Court reach its decision? First of all, it considers the relevant background factual matrix. You'll notice the Supreme Court does not start where all the other courts suggest you do, which is with the simple language of the covenants concerned. The judgment starts by looking at the relevant background. But of course, you do have to consider that in the course of interpreting any contract at some point. So necessarily, these are rather generalized observations about the back. The reason for that is that, of course, leases are very often litigated between parties who are not the original parties to the lease. And so the factual background is unlikely to be very specific. It's going to be a general observation about conditions that pertained to the building or the vicinity of the building at the time. if you're dealing with a commercial contract, then of course you're much more likely to be dealing with the parties to the original contract itself. So the points that the Supreme Court considered were that each of the leases was long, it was acquired for a lot of money. The original parties to that lease, notice it is the original parties, not the litigants that the court's concerned with. The original parties would have realised that the lease was a readily marketable and very valuable asset, but that it would require maintenance to enhance or retain its value. The original parties would have realised that over its lifetime, the lease would require routine works to be carried out, and also that the lessee might want to modernise or refurbish the building or the flat to reflect changing tastes or to incorporate technological developments. A couple of other relevant considerations are set out there. First of all, the parties would have understood that routine improvements would be unlikely to impinge on other lessees, so that it would be sensible for the landlord to be able to give permission to lessees to allow such works to take place. But as against that, also the original parties would have realised the desirability of the landlord retaining rights in possession of the common parts, which would include outer and load-bearing walls, and would also have had in mind the important and active role that the landlord would play in managing the building as a whole. That's the first step that the Supreme Court went through. The second one was it then turned to the covenants themselves. It compared first the relevant tenant obligation clauses and interpreted their meaning. And it said that these two clauses, 2.6 and 2.7, were intended to be read together in the context of the lease and the leasehold scheme for the building as a whole. So an important point there, of course, one doesn't just look at individual clauses in isolation, one looks at them side by side and together. This is something to do with the iterative process, I think, that Zach has referred to in relation to another case. And if one reads the clauses together, the Supreme Court says, it is clear that the two clauses are directed at different kinds of activity. Clause 2.6 at the routine improvements that all lessees would expect to be able to carry out subject to the landlord's approval. Clause 2.7 at activities in the nature of waste, intrinsically such that they may be damaging to or destructive of the building. And the Supreme Court said that it drew support for this interpretation from other aspects of the relationship between the parties, and I've just listed them there: the covenant of quiet enjoyment, the need not to derogate from grant on the part of the landlord, the obligation by the landlord not to authorise a nuisance by another flat owner, and the landlord's own common parts repairing obligations, which were elsewhere in each lease. The Supreme Court drew a contrast with the approach that the parties themselves had taken, and apparently the Court of Appeal had also taken, which was to concentrate on the individual words used. Having done that, the parties had realised that some activities could fall within both Clause 2.6 and Clause 2.7. For example, the cutting of pipes. So if you look at the language of 2.6 and 2.7, you might say, looking at the literal language, that one activity falls within both of those clauses. And since the parties took that route, they found it necessary to impose some sort of hierarchy between the two clauses. And the approach that the Court of Appeal was taking was that Clause 2 trumped Clause 2.6, so that if the activity fell within Clause 2.6, it was subject to an absolute prohibition, and the parties would not be able to obtain, the tenant would not be able to obtain the license of the landlord. So the relevance of that is that the Supreme Court is saying you don't look too literally at the language and make problems for yourself by finding conflicts between two different clauses. You stand back a bit further and you look at it more purposefully than that. And as in this case, you realise that the two clauses are performing different functions, and therefore they are mutually exclusive, and you don't have to say that one trumps the other. Step 3, the Supreme Court then went on to interpret the relevant landlord obligation clause, which was clause 3.19. It pointed out that it's in 2 parts. There's a promise to ensure that every other lease in the building will contain the clause 2 type tenant covenants. That's the first part. And secondly, there's a promise to enforce any such covenants at the request of the tenant, subject to the provision of the security and the promise to indemnify the landlord for its costs. And the Supreme Court said that this is a mechanism whereby any tenant can require the landlord to take action to prevent any other tenant from carrying out a threatened breach. And this was important because there was no letting scheme in relation to these flats, and therefore the tenants had no right to enforce obligations between each other. They had to rely on the landlord to enforce those covenants on the tenant's behalf. So we then come to the meat of this case, and this is to say that the Supreme Court accepted that what clause 319 does not expressly do is preclude the landlord from giving a tenant permission to carry out structural work falling within clause 2.7, which would waive the breach that might otherwise happen. And having reached that conclusion, the Supreme Court then simply said that it was necessary to go on and consider whether the lease was subject to an implied term that would fetter the landlord's right to grant a license. So it then went on to deal with the question of the implied term. And as you would expect, it began by adopting Lord Neuberger's approach in Marks and Spencer and Paribas that Zach has referred to. In other words, you've got to start with the express term. You've got to construe the express terms first. Well, they've just done that. Secondly, you would only imply a term if it was necessary to do so in order to give business efficacy to the contract. And a question you can ask is, would the contract lack commercial or practical coherence without it? Or if it was so obvious, the term, as to go without saying. And thirdly, the term, if you are able to imply it, it must be capable of clear expression. There must be a clear way of defining what it is. On that basis, the Supreme Court held that there must be implied into Dr. Duval's lease a promise by the landlord not to put it out of its power to enforce clause 2.7 in another lease by licensing a prohibited activity. And it said, and it was here adopting what Lord Justice Lewison had said in the Court of Appeal, that it would not give practical content to the obligation in clause 319 if the landlord had the right to vary or modify the absolute covenant or to authorise what would otherwise be a breach of it. And so, in other words, they were saying it was necessary to imply that term in order to give these leases business efficacy. Adopting the commerciality approach, they said it would be uncommercial and incoherent to say that clause 3.19 can be deprived of practical effect if the landlord manages to give consent before another tenant makes an enforcement request and provides the necessary security. Lord Kitchen said this: the parties cannot have intended that a valuable right in the objecting lessee's lease could be defeated depending upon who manages to act first, the landlord or that lessee. And that seems to me to be an entirely sensible observation. It cannot have been intended by the parties that it was simply a question of who could get there fastest finger first. And they addressed one argument that had been raised on behalf of the landlord, the argument being that to imply such a term would confer on each of the other tenants the power to veto repairs or improvements, however capricious or unreasonable the tenant's intentions. They said that argument was flawed because clause 2.7 does not, on its proper interpretation, extend to routine works at all, but it's directed to the much more fundamental works that might be damaging or destructive of the building. And Lord Kitchen said, these are the kinds of work which it is entirely reasonable to suppose should not be carried out without the consent of all the other lessees. And that remark illustrates the importance of the distinction they were making earlier in the judgment between clause 2.6 and 2.7, and their conclusion that the two clauses were entirely distinct and served entirely distinct purposes. And on the basis of all of that, they dismissed the appeal. So Dr. Duval was eventually triumphant.
Thank you very much, Justin. We don't have any questions in the Q&A or the chat, but can I ask you this? In other leases and future disputes where the wording in the lease is not the same as or equivalent to 2.7, how much scope do you think there's going to be for parties to argue that the landlord's argument in that last paragraph is the correct one?
Well, I can see that if the equivalent to clause 2.7 is much more wide-ranging, if the absolute covenant on its proper construction precludes really quite routine works, then I think that argument has rather more force, and it might well carry the day. It's impossible to say in a general way, but my view is it would be specific to the particular wording of the covenant concerned. I don't think that that the dismissal of that argument in this case precludes it being run in another case where the clause has a much wider effect.
Okay, now Stan has got his hand up, and so I've unmuted Stan. So Stan, have you got a question? You're not coming through so well, Stan. Perhaps maybe if you type your question in the Q&A or the chat. Okay. There is another. I'm going to mute Stan, I'm afraid, but there's another question in the chat, which is from Stephen Byram, and he asked, does this case rework the batting order when applying the rules of interpretation?
No, I don't think it does, and it didn't purport to do so. Do you mean, if you mean, do you start with the background? I don't think so. I think you apply, because it's not really it's not actually a case about how to interpret contracts. That's really what I began by saying. I'm on a slight fool's errand. If I was going to deal with how you do it, I would have chosen another case. No, I don't think it does. And in fact, they could have simply restructured the judgment to deal with the interpretation of the wording first.
I thought it actually worked quite well as an example, because you get the court pulling out the background information from the original transaction, and also identifying the key clauses and looking at them linguistically and what elements are in them. For example, the absolute covenant, the non-absolute covenant. And then looking at the structure of the whole of the agreement in order to identify what the words mean. And then they go through the process of construction, they identify you don't have the express prohibition on the landlord of granting the license in that circumstance. So that's the process of construction, which includes all this factual background, includes the linguistic elements of the lease itself. And then they go on to that sort of stage 4, the implied term, and go through the BNP and Paribas. So I rather liked it as a illustration, albeit it's really it shows you how an implied term is used to win the argument.
Yes, it's really about an implied term coming to the rescue of the successful litigant. Yes.
Now Stan's put his question in the Q&A. So He asks, so if the landlord consists of all the tenants as owners, do you need all the tenants to consent?
That seemed to be what the court was saying, that if the landlord is proposing to license the works that would otherwise be absolutely prohibited, they have to get the consent of all the other flat owners to do so. I'm not sure that would be quite right, because not all the other flat owners will be prepared to do what Dr. Duval was prepared to do, which was to put up security. So if the tenants say I'm not interested, I don't, or I'm not prepared to put my money where my mouth is, then I don't think that the landlord has to get permission from those.
I mean, it doesn't encourage good neighbourly relations, does it?
No.
Perhaps it does, because there's going to be less works going on.
No, and there was a certain amount of argument in the Court of Appeal. A number of submissions apparently were made. So said Lord Justice Lewison on behalf of the landlord, that Dr. Duval was being a thorough dog in the manger. But the Court of Appeal said, well, that's not relevant. So, well, they might have thought it was relevant, but if they thought it was relevant, they didn't say so. No, it doesn't. Of course, Dr. Duval's motivation is not relevant to the resolution of this dispute.
Now, does anybody else have any questions they'd like to ask either of us? If you do, you can raise your hand if you're able to do that, and I will try and unmute you. Or you can put a question in the chat, or you can put the question in the Q&A. Anybody want to raise their hand? Well, Justin, I think we've told our participants everything they wanted to know about how to argue contractual meaning, and everything they wanted to know about the license that a landlord can grant a tenant for improvements to his flat. So I think we've done ourselves proud there, Justin. Thank you everybody for attending. As I said earlier, there's a further seminar next week with Andrew Spencer and Ben Hicks, who are talking about employment liability. So thank you ever so much, everybody, for coming along and listening in. We hope to see you again in the flesh at some point, or on one of our further One Chance You Lane seminars, webinars. So thank you very much for joining us.
Thank you all.
So I'm now going to click end, and we'll disappear. Okay, thanks everybody.